Here are three important things that you need to know about PIPs, about performance improvement plans in California. First, there are no laws out there that govern performance improvement plans. In other words, your employer can freely choose who to put on a PIP, for what, and for how long. It's totally up to them, and they don't need to worry about complying with any laws about PIPs because there are no such laws. Secondly, most of the time, although not always, but most of the time, if you're put on a performance improvement plan, it means that your employer has already made the decision to terminate you. And for different practical and legal reasons, they want to make it look like they're giving you another chance. They're giving you the opportunity to improve. Now, why it's important for you to know whether a performance improvement plan is a genuine message to you to get better versus just a symbolic gesture from your employer before they fire you. Because depending on what the real intent of your employer is, you can take certain steps to maximize the benefit for you from the situation, because they might be an option to resign in exchange for some type of severance package versus an option to approach your employer and try to work on your performance issues and maybe make sure that you get out of your performance improvement plan sooner or later, or take any other step that would maximize the benefit to you. Now, you as an employee are in the best position to know whether the termination is coming. You might not be sure, but if you've been with your employer for a while, and the longer you've been with them, the better you're off knowing whether the termination is coming. You need to ask yourself whether, based on how things are going, the termination is coming or not. Or maybe your employer values you, they want you to stay with them, and they have a few specific issues, maybe fair, maybe not fair, but they have a few specific issues with your work, with your performance, with your attendance that they would like you to work on. And the third important thing to know about performance improvement plans is that contesting them, arguing with your employer about your performance deficiencies, trying to prove to them that you're right and they're wrong, is not only pointless and useless, but most of the time it's counterproductive. It makes things worse, it makes your relationship with your employer worse, and it makes any chance of you being terminated even higher. Because think about it. You come to a higher management or you come to HR and you basically say, I'm right, my boss is wrong. What's going to happen? Are they going to say, we're sorry, yes, you're right, your boss is wrong? It's not going to do anything good. It's not going to help in improving your situation at work. It's not going to help you negotiate a better deal for yourself if you decide to resign and you would like to get some kind of severance. Most of the time, challenging your performance improvement plan or challenging any type of warning or disciplinary notice for that matter is not only pointless, but most likely it will be, again, counterproductive to any type of effort to improve your situation, whether you stay with the company or not. Thank you.